Gotta get my thing. I'm a mess. All right. Let's see here. Let's do sapphire, I think, and a labradorite. I think that would go nice. That was nice and easy for me compared to everything else today, which has not been great. That's all right. We'll make it through to the other side, right? Oh, fingers crossed. Today's been crazy. All right, here we go. Let's turn this on. Man, all the fiddle farting they're doing with this app is just ridiculous. In case anybody wanted to know my opinion on it. It's ridiculous. Hello. Hi, everybody. Sorry, I'm getting one more thing here sorted out. Hopefully we'll get it sorted out. Okay, it's been a while since I have done a live. I think it's been maybe 3 days. Hello, Dolores. Hi, welcome. Hello. Hi, Mama Vanna. Welcome. Yeah, so it has been a couple of days. So I've got, some, there we go. I have to remember some things here. Oh, come on, be my buddy. Got my little thing going on over there. Not helpful. Whew. All right, how is everybody doing? Are we making it? Are we making it through? I'm not sure. Today. I'm not making it through anything today except for maybe a cheesecake, and unfortunately I don't have one. But yeah, that's all right. Okay, I agree. And I agree. All right. It's a good thing I've already read all the terms. Don't ever assign anything or agree unless you've read it, right? So there you go. Whoo, all right, we made it. We're back on. Hi, everybody. Welcome in. 5:30 today, my time. A little earlier or later. I don't even know anymore. Everybody. The world's crazy, so I'm not even sure at this point. I've got a mixed bag for us tonight. Oh, thanks, Erin. My goodness, what would I do without you? Yes, please, I do need more paper clips. Paper clips, those would be great. Ooh, and staples, although, I don't know. I feel like they're going the way of the penny. Well, welcome in everyone. So, it's been, we've had a busy, 6 weeks, 12 months. It's been busy. So I've got a lot of things to catch us up on. And I want to kind of focus tonight on, well, first we've got the whistleblower. So I want to take everybody through this to kind of explain how the Fourth Amendment is actually supposed to work, because, that's a thing. So we'll go through the whistleblower here, and then if we've got more time, I would like to just dabble here in the posse comitatus. And then I've also got, because this is what I keep hearing, whenever I'm over with Amanda or hanging out, there's always these questions about what asylum actually means, right? So we have that. And then we also have this section here, 1325, of improper entry by an alien. So I've got a couple here. We can go through and look at those definitions. That should be helpful. So much has happened. Oh, I know. It's been too much. Like, who do we ask to, stop it for a while? Can you put this on pause for a little bit? That'd be great, because it's kind of crazy town these days. All right, so I've got this, and then also I finally did this properly. I have picked out a very fun case for our bonus case. So what I've started doing, everybody, hello, Mr. Toby, June Marie, hi, welcome. Once we hit 100,000 likes, then I will read a bonus case. So a historical case that the U.S. Supreme Court has decided. So tonight is a First Amendment case. It's a really good one. So, yep, get your Yep, get ready to tap, but don't hurt yourself, all right? Take breaks, do stretching, all of those things. I'm doing all right, John. I'm doing all right. You know, I tell you, you probably all are feeling this too. It's kind of hard to keep spirits up when there's just so much garbage everywhere. But I'm getting through it. I'm getting through it, and I do have to admit I am spending a lot of time with Atticus, and I'm not sure if it's consensual. As I just carry him around the house. And he's like, I do have legs. I'm like, I don't care. I need a cat right now. So that's been working. I love that. Nona, hello. Hi, Shar. Hi, Bad Ziggy. Oh, I haven't seen you in a while. I don't think I've seen you for a bit. Bad Ziggy, welcome back. Oh, thank you very much. Yes, the kitty cuddles, you got to have them. So this is one of a set of, well, I don't know, how many did I get? Several that I got from an artist on Etsy. And I've gotten a lot of pens off of Etsy. This is not sponsored. This is art. So this is not something to purchase by hitting a link and leaving. All right. Oh my gosh. I really hope they don't ding me here. Anywho, these really cool pens have turned into wands, and I just absolutely love it. I love it because, and for me, it's well, I'm not going to get myself into trouble again, but it's just a great all-around pen, very comfortable to use. Thanks, Storm. Yes, kind of got the mermaid today. I thought these were just blue, but under this light, they're actually flashing purple. So I'm just loving that. Loving that a lot. Right, refillable, no, but not the ones that I have, but there are others that she has on there, and I think they are refillable. Yes, hello, Francois. Hello, welcome. Midnight Blue, I think that's right. Oh, hi, Dolphin. Oh, thank you so much, the mixologist. I appreciate that. All right, everyone, let's dive into it. It's been a rough few days. We're going to make up some time in the air here for us. Lots of information that I want to share tonight that are going to be your foundation pieces as we go into this next era of crazy, next crazy era. So there are a few things going on right now. First, we have this whistleblower anonymous filed letter here. Well, and it's, wow, it's a lot. It's a lot. And that is the background for the idea that the law enforcement can somehow go into your home without a warrant or probable cause, which is not correct. So we'll go through that. And then I've got the Constitution to back us up on that. Oh, where'd we go? Okay, here we are. I have a little bit of a different setup tonight. I'm trying something a little different here with my lights and stuff. So let me know if it works out okay. And if not, just let me know. We're not in the bunker yet, but I'm starting to feel like I need to write somebody a letter. That's where I'm at right now. A very sternly worded letter. Yes, Fourth Amendment violation. Absolutely, absolutely. And we'll walk through that too. Today, I know. We'll work together, Spooky. We'll work together for sure. So the Fourth Amendment, everybody, is that right against improper searches and seizures, right? So and let me just show you real quick. If we look at the Fourth Amendment in here, let's go Roman numerals, whatever. That's the 14th. So what I'm going to be looking at here is another 10 amendments. There it is. All right. So search and arrest warrants. Now, our warrants are actually in the Constitution, the requirements right here. The right of the people to be secure in their persons, right? So that's where we have a lot of questions when we're doing searches of persons. Houses, right? Castles, your house. Papers, that's come up in multiple cases too, what exactly a paper is. If it's some kind of a document, and even now literally online, right? We don't even use paper. Most people don't, I do, but and effects. And this word effects also has caught up the judiciary several times. So whenever we have kind of a, I'm not really sure what that means exactly moment, like for papers, which were just, get your quill out at the beginning, and effects, which can be a lot of different things. Those needed to be interpreted by the Supreme Court, and they do that. So that's kind of fun for them. Hi, So Unique. Welcome. Does it say castle, or should I sell mine just to get a house? Oh, Jobu, no. This is not a seller's market. I would keep that. Keep it for a couple more months. See where we're at. Oh, thanks, Rachel. All right. So here's the fourth again. Now, we're needing to figure that out. So against unreasonable searches, what I'm trying to take you through here, even within the language of the amendment, is there are a lot of different interpretations. So, but those interpretations need to be followed. So no unreasonable searches and seizures. So what's unreasonable? We'll have to look at case law. What exactly is a search? Case law. And what's a seizure? Also case law. So when we're talking about arrest, that would be seen as a seizure. Temporary detainment, not necessarily a seizure, depending on the circumstances, right? So after that, shall not be violated, right? More hot cocoa for me tonight. And no warrants shall issue. So there's our warrants clause that was a huge issue back in the colonial days. My goodness gracious, the violation of the rights were just like right in your face. Like you didn't have to look for a civil rights violation. You just would exist, and they would like take your stuff and move into your house, and stuff is awful. So you have to have warrants, but the warrants have to have probable cause. That's really important. Probable cause, very important here. And I've talked about that before. Reasonable suspicion is lower than probable cause, which is lower than beyond a reasonable doubt in criminal court. So you got to have probable cause. And then it has to be supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So even here they're saying we can seize your person. So again, you have to be careful. So the particularity, oh my gosh, it's so hard with the R in there. Particularly, okay, this has to be written out pretty carefully, all right? We've had some clerical errors in the past where, they're like, man, you just got it off by 2 numbers. That's okay. Meanwhile, in another place, it's like you have a complete wrong person, actually. Right? So figure out the name before you try to go in and do the warrant. Right? So you've got to have a proper warrant here. And then if you do, you can seize a person, you can seize a thing. You can't seize a castle, Jobu. So again, I would recommend staying in the castle and inviting any of your friends over to hang out in the castle. Highly recommend. All right, so that's the Fourth Amendment. That's what we're working on here when we're talking about this whistleblower. Now, I was very worried. I know a lot of people were worried that we were going to lose the whistleblower road because of everything that's been pulled, right? The inspector generals have been pulled. Office of Legal Counsel for the executive branch is gone, or there are people there that are incompetent. We've got some problems here with the checks inside of the executive branch, which are like the first layer, right? So it has to go through the executive branch, whatever, what they're doing. And then the executive branch is like, no, we can't do this. Take it back, do something different. They don't have those people anymore. They're gone. All those people are gone. Even the librarian is gone, right? That one really bothers me. They kick the librarian out. Anywho, so all of that kind of stuff is gone now. So everything's just like a straight, they're just going as fast as humanly possible, like Mario move, apparently, and just jumping into the flames. And so we don't have a lot. But I'm glad to see the whistleblower road is still open and available. So that's very helpful. Yes. Is it Baron or Baron? Only loyalists left. I agree. And what's good about that? Nothing. Oh, thanks, Kimberly. Aw. Yeah. Right. So we got to be careful as we start going through things because people are getting charged and arrested and taken to places and moved around without due process. And, so life's gone crazy, but we have a whistleblower now. So this was January 7th of 2026. So let's put the date up here. We're going to start with the month first, right? And then we have the whistleblower. I'm just going to call this whistleblower because there's a lot of other pieces that can go to this that are not just reports and stuff. All right, I gotta stop talking while I spell. Whistle blower. And the thing is, the word's just right there. I just have to copy it, but yeah, you never know. All right, so we've got Fourth Amendment here. And then I'm gonna put in here versus the administration. All right, and that's really what we're looking at here. Right. So, and again, also remember that warrant requirement's also in the Fourth Amendment as well. Oh, I'm so glad, Weather Girl. Hopefully it's helpful. So I'm going to go ahead and dive on in. Moderators, let me know if you need a hand. Everybody, please be respectful. This is our learning environment. We're not debating whether something's good or bad or policy or people. We're just kind of learning here. All right. So let's dive in as we go. It is hard to talk and write at the same time. And I'm just thankful that I don't write bad words, honestly. All right, January 7th of 2026. This was sent via email. We've got several lines redacted throughout this with information about specific people. And of course, that's to protect their anonymity as well as to try to keep them safe. We are in a very interesting situation, much like, honestly, much like what our courts were looking at in the 1930s with organized crime. So the judges and various people, they were scared, right? Because people are going to go after their family, and they did. So now we know more, and we are able to hopefully catch it on the front end before it gets too bad. I'm not saying that's happening now, but I'm saying it's definitely left its impact on us. I know, El Jenny, I know. All right, what I'm saying, that's all right. That's all right. All right, here we are, January 7th, regarding a secretive DHS memo authorizes ICE to illegally enter homes without a judicial warrant in violation of the Fourth Amendment. So again, your home is sacred. If you've got a car, if you are just walking down the road, or you're just sitting at I don't know, where do people sit these days? I don't ever leave my house anymore. I'm like, I don't know, Pizza Hut? Is the Pizza Hut still there? I'm not sponsoring this. Oh my gosh, I've been burned. We're going to just call it pies. Maybe you're sitting at a pie shop, all right? And they come up to you, whatever, your toast. But when it comes to your home, that's your castle. And so that has the highest level of protection. Oh, bus stop, that's a good example. All right, so number 1, whistleblower aid represents 2 anonymous United States government officials disclosing a secretive and seemingly unconstitutional policy directive. This policy directive, which could also be called an executive order, all right, so it's not a law, it's a policy directive. This policy directive authorizes Immigrations and Customs Enforcement, so the CUBE agents, to enter homes and residences without consent in order to conduct arrests and removals without a warrant issued by a federal judge. So again, this is a report that's been sent in. This has not been through the courts. This is just, the whistleblower's point of view, right? Now, first one down here is an exhibit. Exhibit regarding the memorandum from the Mr. Lyons fella. So I do have that. Let me see if I can pull that up here. I'm all over the place these days. Oh, where was I? Here we go. Sorry. So right here. I put it in a spot where I wouldn't forget where it was, right? Hi, Ray. Hello. All right, so Exhibit 1 is a memorandum from Acting Cube Director here. And this was May 12th of 25. So this is the letter that or the memo that they're referring to. And a lot, just as a quick side note, everybody, a lot of the lawsuits, and there have been a lot that have been filed. I don't even know anymore. Well, that's not true. It's about 600. But what you'll see in a lot of them is a copy of whatever it is that they did that was unconstitutional. So here's a copy of something that's unconstitutional. Now they're going to take to the court and say it's not unconstitutional. But as of the reading of this, it is not constitutional. So let's take a peek through it. Exhibit 1. I know I'm coming for you, Mr. Marty. I'm on my way. Good to see you too, Wes. All right, here we go. From Todd Lyons, the acting director. Subject, utilizing Form 1205, warrant of removal. This is, again, this memo is like in-house. It's through the executive branch. Thank you very much, VC. Appreciate that. So January 20th of 2025, the orange, I use that so that I don't get knocked around in the algorithm. All right, everyone. Issued Executive Order 14159 called Protecting the American People Against Invasions, directing the Secretary of Homeland Security to ensure the successful enforcement of final orders of removal, which I think's great. Like, yeah, do that, right? And then they're putting out where that is in the Federal Register here. This is the best copy I could find, everyone, truly. So I know it's a little bit weird, but all right, so January 20th, 2025. Right, and this was an executive order essential to the removal of aliens subject to final orders of removal is the ability to locate and arrest them. So as I go through this, I'm going to just hit the highlights where I believe the information is not actually correct. So I don't know, but at first glance, I'm not sure arrest is the proper word. Again, because that's a criminal situation. So, I suppose every time law enforcement removes the ability for someone to move freely, it could be seen as an arrest, but it's a little bit suspect, in my opinion. To this end, certain supervisory immigration officers within both enforcement and removal operations, so ERO, and Homeland Security Investigations, HSI, are authorized to issue an administrative warrant. This is what kind of bologna sandwich was going on in Wisconsin. Everybody remember the judge in Wisconsin who they accused of trying to help someone leave and not be caught by the cubes, right? So that was difficult. I think she was found guilty, by the way, of, I think, like an interference charge. All right, here we go. Here is the administrative warrant. So Form I-205. So everybody, if you're wondering what that warrant of removal looks like, just pull the form number up and you'll have it. I'm going to put it here so in case you can't see it very well. Here's the form for the administrative warrant here. And again, if it was just a regular warrant, we wouldn't be having special pieces, but it's not. This is a unique to immigration kind of a situation. All right, so here's the form. You can pull that up if you are so inclined. Oh, I think she's going to. She's still got time, Doughboy, before her window to appeal closes. But yeah, I mean, that's definitely. She did resign. I can't remember exactly when, but it was just maybe a few days ago. I think she did actually resign. Here we go. There's the form for the arrest of an alien with a final order of removal. All U.S. immigrations and customs enforcement special agents, yeah, there's something special about them, and the deportation officers are authorized to execute Forms I-205 here. All right, and this is the Code of Federal Regulation, in case you want to look that up. Although the U.S. Department of Homeland Security has not historically relied on administrative warrants alone to arrest aliens because it's not constitutional, subject to final orders of removal in their place of residence, the DHS office and the General Counsel has recently determined that the U.S. Constitution, the Immigration and Nationality Act, and the immigration regulations do not prohibit relying on administrative warrants for this purpose. That's a load of crap, all right? They're, again, trying to twist this around here and say that administrative warrants aren't covered by the Fourth Amendment. The thing is, anytime a person has the government involved in taking something, including their person, the Constitution clicks into place. So they might say, well, administratively, the Constitution doesn't blah, blah, blah. It doesn't matter if it's administrative or not. This is not legal advice. Legal education, everybody. So double check, take a look at these pieces here. But if you are going to be restrained, they need to be making sure that that Fourth Amendment piece has come into play regarding due process and that you haven't unreasonably been searched and seized. So there have been lots of cases when we've had a situation where it was a quasi-criminal situation, and it's like, well, you can go in according to the Constitution. The one area where the Fourth Amendment is not going to help you is if you are on probation. If you're on probation, your probation officer can come in and dump your whole room out or whatever without looking twice. But anything else has to pass the Fourth Amendment. They're trying to get around the amendment, which is interesting because they're trying to say, well, it's quasi-criminal. Nope. So just remember that. Oh, yes. Yes, indeed. Hello, Victoria. All right, so warrants for this purpose. Again, this is like red flag world. When you're saying the Constitution doesn't cover something, then you should be looking to the 9th and 10th Amendments. So that's just it. I mean, you're like, well, it's not under the 5th Amendment, so boom, we don't have anything to say about it. No, that's not right. Look to the 9th and 10th. So then, warrants for this purpose. Accordingly, in the light of this illegal determination, what the H, light of this legal determination by some random person in the executive office. You know who I mean when I say random. ICE immigration officers may arrest and detain aliens subject to a final order of removal issued by an immigration judge, the Board of Immigration Appeals, BIA, or a U.S., and then I'm going to turn the page. So to say that there's under ICE, under the immigration, if you've got a final deportation, finding against you, ruling against you, or the judge is like, you got to go, we're dealing with a different world then, all right? If your paperwork says you got to go, then you go down the got to go road. But this is really a situation before all of that paperwork is sorted out, right? So we're not talking about, just going in and invading and kidnapping people who are like, well, you were supposed to, hop on the train yesterday and you missed it. No, that's not what we're talking about here. No, we're talking about people in their homes and they're like, knock, knock. We think one of you may have blah, blah, blah. And that's not okay. That's the reason why we have the Fourth Amendment. All right. But they like to kind of argue that, this administration does. And I think they like to try to pull out different novel legal questions. And I think that's great if you're having a happy hour after work, but for an entire country, and then to try to put it into some kind of rule, that's doesn't seem the best, best idea here. All right, here we go. Or a U.S. District Court judge or magistrate judge in their place of residence. CUBE immigration officers should consider all available enforcement mechanisms. And this is the implication then, everyone who's been there did not do that. So are they trying to say all of the CUBE's didn't follow their own rules. They just did whatever they wanted to. No, including the use of Form I-205, which we just talked about, to arrest an alien in their place of residence to achieve the requirements of Executive Order 1459 in accordance with the applicable law and policies. This is the other place they like to pull this kind of crap here, is that they'll come in and they'll make a statement. Let me give you an example. So the tariffs, right? Tariffs go through Congress. Anything that has anything to do with other countries and money, that's all Congress. The only way the president can get into those kinds of powers is if it's unlocked from an emergency that's been declared. So we've got an emergency due to an insurrection or an attack by another country. Those two roads will unlock the ability of the president to do this kind of tariff crap, right? So the big issue is we don't have that emergency. So I went back through all of the executive orders and I said, well, where's the emergency? It's one sentence. And the one sentence is, the president has determined we are in a state of emergency. Boom. And then they move on. And this is what we're going to do about it. So that one sentence has created this situation where the president's just saying, I think we have one. And now the entire country has all of these extra powers unlocked where harm can potentially be done. Very frustrating process of trying to do that. And then at the very end, of course, they'll say, well, we're not trying to interfere with any applicable laws, because if we did, that would be unconstitutional. We'd have some impeachment issues going on. So if you're doing compliance with applicable law and policies, you're not going to be able to get both things. You cannot have, what am I trying to find? I'm trying to find a word that's not the G word. You cannot have like a secret police, all right, and say that you're following all applicable law and policies. Because if you were, you could not have a secret police, because that's how it's written in the law. All right, so there you go. Who's the judge who signed the warrant for Fulton County? No, I don't know that we do. Yes, so he's been, this orange fella's been breaking all kinds of laws, hundreds and hundreds of laws for sure. That's kind of what he's been doing. Now, quick reminder about the, I'm glad you brought this up, about the Georgia case, right? That from day one that it was filed, they've been asking for these voter rolls. So I want to give you a little quick moment here. In the RICO case in Georgia regarding 19 people, including Mr. Orange and a whole bunch of other people, they are represented by different attorneys. So each one has a different attorney. It's just a nightmare for judges. We've gone through preliminary motions. That's what we did the full first year, went through some of the evidence. The entire time, since day one, they have said, we want to see your voter records. So the Secretary of State, various other people are like, well, you can't see our voter records. Those are private. And they said, well, we think it's important for our RICO case, because we want to show that what we were saying is true about the hullabaloo that's been going on with the county, whatever. So Judge McAfee for like 18 months was saying to the government, dude, get your stuff together and give them the stuff. That's okay. They can have this information. That's not in a place where they can't pull information legally. So then the powers that be that kind of run where all of these different voting records came in and said, we're going to need like a whole division to come in and look through all of this stuff because it's, pen, paper, whatever. So it got pushed and pushed and pushed. And then just recently, the Georgia case got pulled, right? But there is still this ongoing investigation that they wanted to do regarding the voter records in Georgia, right? The case is dismissed without prejudice, gone. So now the only way to go after those same records they've been trying to get this whole time is for the FBI to say, we're going to go and investigate And so we need all this crap. The thing is, the FBI and the Georgia FBI had already put years into double checking, making sure all of these numbers were correct, and came back and said they're fine. So that's already been taken care of by the good guys. But now the bad guys want to come in and be like, well, we didn't get to see it. So that's what they're doing. They're going through a whole bunch of voting records. They probably don't even know what they're looking for. But that's kind of how that cookie crumbled. Just a quick backstory, because that's hitting the headlines really hard, like it's this big, big, huge thing. And it is. Don't get me wrong, it is. But it was a huge thing that was decided 2 years ago, is I think a better way of putting it. Isn't the investigation just a ruse to get the data? Sure. But you can be rusy. You can do the ruses here, right? He would pull cubes. Oh, now that, Mama Vanna, is quid pro quo. That's a different beast. That's a different animal. Because he's taking basically military power and saying, we're here as long as we want, unless you give us what we want. That's a quid pro quo, and that is illegal. The fact that Bondi said that out loud still is like, dude, are you a lawyer or what? Because that's quite disturbing as well. Can they add fake into those docs? So the thing is, Teeny, and I'm glad you asked here, everybody. I'm not forgetting here where we're at, but when those cases started hitting the fan, all right, all of them, I pulled all of them. I think I pulled like 84 cases. And within those cases from around the country, of course, in the swing states, but some other states as well, they would attach the evidence to make sure there was probable cause to even come forward on an indictment, which is still just this much as probable cause. Over here, beyond a reasonable doubt, that's a lot more work. But the evidence that they submitted was rubbish. That's what the problem was. We had multiple statements by people who were determined to be completely fraudulent, or they had had fraud convictions before. And so there was questions about eyewitnesses, and they were good questions. It wasn't like, okay, who do you vote for? No, it was, how far away from the mailbox were you? And the answer was, wait, did I say a mailbox? No, I meant they were in the back of my car, right? So really suspicious stuff like that. And another thing too was to talk about the voters in Georgia, because he was all over that, right? Like a cheap suit. So that information had already been gone through. Those voter records had already been taken care of. So now the question is, well, since there's a new investigation, can people go in and add a bunch of stuff? To which my answer would be, that would be really hard. That would be super hard to do. It'd be a huge project with zero gain to it, if at all possible. But from what I've seen of how they handle their votes there, all of that stuff in Georgia, they're very careful. I mean, that's tight security. Sure, clerical errors get made for everybody when you're dealing with this many people in one state, right? Of course, there's going to be clerical errors. But overall, the system that Georgia uses is solid. And a lot of people explained that right after all of this stuff started happening. So here we are a couple years later, and they're still, if they don't find anything, they're going to make something up. In my humble opinion, they're going to make it up. 2020, I think, will absolutely have a negative impact for us for several of these cases as time goes on. And that's the legacy of the orange. The legacy of the orange was that no matter what, even when we were going through a war, we were able to properly go through the voting process. And now we've had this orange fella, and it's going to be a question every single time now. All right. So here, this is who I'm talking about here. All right. And again, I say orange fella because I don't want to get dinged. Oh dear. The makeup here. The makeup. They're going to make up something when they don't find. Well, and it's possible, and they've done it before. So And they don't have anyone coming in and saying, knock this crap off either because they've gotten rid of them. So we're going to have to see how the whole process works. One thing, though, to remember is if they do try to go down that road, I would remind everybody how slow the judicial run is. So just keep that in mind. I'm just showing this to remind everybody. Oh, my goodness. Because I can't see it on my, on my main camera. I can only see it off to the side. Oh, my goodness gracious. So this is the all of the people who were charged, right? We had 4 that went forward and pled guilty. They got the RICO off the table, and then a couple of years of monitoring. It was, no biggie. The big thing they needed to get rid of was the RICO charge. So these people were like, dude, let's just get her done. Let's get it taken care of. I want to go forward in my life. The rest of them were like, nope, this is all we're doing for the next 10 years. Just do it. So for a while, we just had cheese and crackers up here trying to get a speedy. But then Ellis came in. But these are the people involved, and they were all charged, unlike in the DC case where only the orange fellow was charged. But there were uncharged co-conspirators, and I think Jack did that in order to keep his world nice and clean with what he was handling. But just a reminder here, we've got the card. Are they all out of jail? Yes. Yes, they are. Are they all in very difficult life situations? Also, yes. So, although probably not Sydney. She's got enough money squirreled away. She should be all right. All right, Mr. Lemonade, Mr. Cheeseburger. That's right, Boxer Mom. Oh, that's old school. That's a long time ago. All right, back in it here. All right, this is, again, I'm reading through the May 12th letter from 2025 that was given out regarding whether or not the Fourth Amendment search and seizure bits were pulled in. All right, so here's the general guidelines. Again, this is a memo. Number 1, the Cube law enforcement officers receive extensive training on the legal and procedural requirements for making administrative and criminal arrests. The Cube's personnel must remain cognizant of all existing laws and policies pertaining to arrests when carrying out civil immigration enforcement actions. All right, so I like what they're saying here, but I don't believe it. How's that? They should have extensive training on that. They should understand the procedural requirements. This is how it's supposed to be, but is it true? I'm not so sure that it is. I'm really not. I'm not hearing anything off the street saying, yeah, they're like, woohoo, we want more training. No. No, they need to be trained to keep their weapons to themselves, right? I mean, come on. Anyway, number 2 paragraph, prior to entertaining prior to, I don't know what's on my mind tonight, everybody. Prior to entering a residence to conduct an administrative immigration arrest pursuant to Form 1205. This is a really important form here, apparently. Officers and agents must ensure that Form 1-205 is properly completed and is supported by a final order of removal issued by an immigration judge. So again, this is interesting here because they're saying, I believe someone with a valid deportation opinion is in the home. And so now we're going to go in and grab that person. There are different ways you can do that. If you believe that someone is in a home and you're trying to serve a warrant, right? There are different roads you can go down. But I'll tell you one road you cannot go down, which is knock, knock, we're the police. We're here for, we want to talk to Bernie. There's going to be an arrest. That's not enough to just cross over that threshold, right? You need probable cause. You got to have a warrant to search. You've got to have a warrant to get you in the house. This one, though, they're saying here, because we've got a final decision from the court, we can just go into the house. And that is just not how it works in criminal law or any other ones. because that would be a violation. And if you look at these warrants too, these administrative warrants, I don't see anything wrong with them other than they're just signed by their buddies, like during lunch hour. Fine, as long as they're not violating constitutional rights and privileges. And this one would be if you think you could just go into a house. And this was almost the exact same set of facts in Mapp v. Ohio. Now, Mapp v. Ohio was the case where the courts finally had enough of the BS from the coppers and said, look, dude, if you get evidence here in this way that's illegal, you're not going to get to use it at trial. So none of that evidence will be usable because it'll be excluded because you had a bad search. All right. So just as a side note to that, literally couldn't enter unless I know. Well, the other thing too, the other thing, and I'm sure you all have gotten this as well, the one thing that really worries me is that, sure, they'll break into the house. It's against constitutional rights. Fine. And then they go and arrest whomever they want, again, against constitutional rights. And they put them in the jail. And then the people are like, whoa, I need a lawyer. We need to file some stuff. This is crazy. We've got constitutional law violations. And the lawyers are like, all right, pick me. Here we go. I'm here for the love of the game, not for the money. So let me help you. And then the next day, they're in El Salvador, right? That's the scary part that's going on here, is that if they determine they don't want to deal with something and there's no judge originally telling them literally not to ship them abroad, they're on a plane to Djibouti, and this is the part that is the most worrisome, in my humble opinion. Fruit of the poisonous tree, exactly right. Right. So again, we're not just talking about, let's file some stuff and, make friends in the jail and, wait for our day in court. Your day in court's not going to come if they put you on a plane into a country that's not a good place to go vacationing. All right. I don't want to diss anybody, but fabricating legal documents to avoid, well, of course. And when you have someone, clearly they've got a couple of legal people in their world. I'm thinking it's probably this Eastman fella, because he was a constitutional law professor before he had both of his licenses removed as an attorney. Man, he's such a jerk too. If you go in and watch the quote unquote trial for the loss of his law license, man, that guy's he's very unpleasant. So I think he's probably part of it. And then I think they've probably got a couple other people in there. So it has this kind of essence of the law, but it's not enough to take it to the next step. And that's what the judges are calling out now. They're like, look, we gave you time to get yourself sorted out, but you actually need to take it across the line, not just talk about it for funsies. So yes, I think that's very interesting that they could do that. And everything is being watched very, very carefully is the other thing. Like, did you guys think you'd be able to do this and no one would notice? Like, that's, we learned about that one the hard way. So, Dershowitz, yeah, probably. I can't eliminate anybody. Maybe the My Pillow guy person. He's probably just there for like the halftime show. Like, boy, my arm's tired. You know what I mean? Also, everybody, look, not all my jokes can be winners, okay? They can't all be winners. Here we go. Before entering a residence pursuant to Form 1-205, ICE officers and agents must knock and announce. That's great. If they had not included that, it would be a no-knock warrant. Very, very controversial. Thank you very much, Big Grandma. Thank you. No-knock warrants, which we've heard a little bit about, are very rare, need to be very rare, and have a very difficult time holding up in criminal court unless they're done very, very, very carefully. In announcing, officers and agents must state their identity and purpose. All right. Following announcement, officers and agents must allow those inside the residence a reasonable chance to act lawfully. That's interesting. I don't even know what that means, especially when you've got the cubes out here that aren't actually following the law. So I'm not sure they're going to know what that even means. Like, do you give them 5 minutes and if they don't comply, you throw them in the truck? I mean, That's what happens when you go forward in bad faith and you're a law enforcement people. Like, I don't want to think that the cubes are going to come in and just grab people and shove them in a cart, but that's what they're doing. that's what they're doing. So it says, only use necessary in a reasonable amount of force. What does this not say? Unaliving force. Necessary, reasonable, not unaliving, to enter the alien's residence. Again, that's the castle, right? So they're coming into the residence, following proper notification of the officer or agent's authority and intent to enter. So this is really rough. They're at least giving some instructions, but if they're followed, who knows? It's been a rough one, Big Grandma, I know. We all go through it, don't we? Then you go out the other side and you look back and you're like, what was that? That was crazy. All right, to be clear, a Form 1205 is not a search warrant. That's important, all right? That's because there's certain things that unlock with a search warrant, certain tests that are applied, certain exceptions, certain ways that things have to be written down. So they're saying it's not a search warrant, which is great because that would be unconstitutional, and should only be used to enter the residence of the subject alien to conduct an administrative immigration arrest. That's no, that's not quite right. Here, an administrative immigration arrest, which is again kind of a quasi administrative world, right? So you're going to enter in without what you need in order to possibly arrest someone in an administrative case. That's not how that works either, right? And anytime we're noticing, let me see if I can draw this. I've worked for years on this, everyone. Anytime you hear this kind of crap, it basically means they're fishing. They're like, if we can just go into enough houses with brown people, we will eventually come up to someone that doesn't have their updated paperwork because they're going into court next week. You know, they're trying to really take advantage of the situation. And without something stopping them from entering the homes, it's going to be crazy. And I forgot. So Map v. Ohio up here. This is, well, I don't want to get too far into this case. One of my favorite cases. You can listen to oral arguments online, which is at oya.org if you want the Map v. Ohio case. This guy sounds like, oh, I know it's old school, everybody, but does anyone remember that really big talking rooster guy from like Bugs Bunny? I barely can remember him, but he had this weird way of talking, like, you know, Kentucky Fried Chicken. Maybe that was his name. I don't even remember. Anywho, it's basically like two old school, like, rooster fellas yelling at each other, and it's hilarious. Foghorn Leghorn. Oh my gosh. We're winning tonight, everybody. Yay, we're winning. I'm like, no one's going to know that reference. Oh my gosh, I appreciate you all so much. I appreciate you. So basically, her attorney and the government's attorneys are like two with like these big drawls, and they're like yelling and gesticulating, and the judges are like, I'm going to need you to calm down because they're all sleeping behind the bench, and then this very loud set of attorneys. Anyway, you can go look this case up and listen to those oral arguments if you're so inclined. Oh my gosh. Yes. Right. Okay. Birds. Wait, I get distracted by birds. So we got to be careful here, right? Once inside, again, they're saying they can conduct a limited search of the immediate area. So here's another problem I have with this, everyone. As someone, you know, who's worked in the criminal law world for a long time, a limited search. So there's a lot of stuff that unlocks when you get inside of somebody's house, right? When you pass the threshold first, anything that you see can now become a crime. Meaning if there is anything in there, for Miss Mapp, it was corn that they saw, and it could be anything. So if they just walk into your house, plain view allows them to look, and if there's something illegal, then boom, it's confiscated and you can be arrested. That's one of the reasons why you need the castle doctrine, right? So that's one of the exceptions to a search warrant. So even if they came back and they said the search warrant was bad, then they would have to pull all the other evidence as well that came from that search warrant. All right, so search of the immediate area. Now, also, the search of the immediate area is another exception to the warrants clause, and this is a search incident to an arrest. All right, so we've now got two full exceptions to the warrants clause with just these few words here. Right? So if you are being arrested, then the area that you can touch, or the wingspan area, is within your reach. You could still have some problems when it comes to being charged with things, right? Hello. How long until they start arresting people in where? That's a good question, Harambe. I don't think they're going to go down that road, in my humble opinion, because they're already maxed out, in my opinion. They're already maxed out trying to get the people and the voter records and to get back at different people he doesn't like. So I'm thinking that the wacky tobacco situation may come up, but I don't think it's going to come up very soon. It'll be a little while. So here we go. Let's move on to the next piece. Here is the next piece. Again, this whole thing is about this memo. So we're taking a few extra minutes here. So ensure officer safety only. So they're saying the equivalent of a Terry Pat, but that's not the, you can't just do a Terry Pat when you have broken in with no appropriate warrant. I'll come back to that later. No Terry Pat here, people. Any evidence of a crime observed, I just said that, where the incriminating nature is immediately apparent, again, that is the plain view doctrine, may be seized under the plain view doctrine. Oh my gosh, look at that. It's like I wrote it myself. I did not, and I've never read it, but that's all right. They know where the problems are. They're right here. Consistent with longstanding practice, ICE officers and agents should not generally enter a residence before 6 a.m. and 10 p.m. And above all, officers and agents should take reasonable measures to ensure officer safety. So officer safety means the removal of any weapons, all right? That's just what it is. If it's something that can be used for a weapon, or if it is a weapon itself, it needs to be gone. That's the only way to truly do the officer safety. So in the legal world, when we say that, we're talking about any kind of weapons that could cause harm. All right, so this is old school, 6 a.m. to 10 p.m. Used to be, and I don't know, I'm not sure. Some states probably still have this rule where you can only do a search warrant during daylight hours. If you went and knocked on a door in the evening and had a search warrant and it was dark or whatever, your search warrant might get kicked out. There has to be special language that allows for you to serve a search warrant on somebody at night. So this is just old school. It goes back to like way before women had the right to vote. You know what I'm saying? But this is just part of making sure everybody's covered in that situation. Yeah, anytime of the day, VC, I don't doubt it. Yeah, and 10 p.m. is really late. It is late, and I think they're just trying to cover, all of the basis for those nighttime warrants, which still do occur, don't get me wrong, but the language is historical. Here's our exceptions. So let's see what they're actually going to say about the Fourth Amendment here. Right, and again, just remembering that, it's in the Constitution. When we're looking at rules, this is the other thing too. Some people get really upset. You know who the people are. And they say, well, they're not here legally. They are not allowed to have any rights or privileges or whatever. And, to that our answer is, after the Civil War, that was not the war of Northern aggression. It was a civil war. We had the 14th Amendment come out. Everybody had to sign it. And in here, it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, right? So we know this is going to be aimed at citizens, privileges and immunities here, right? But then if you keep going, actually, I'm going to back up a little bit. We've got all persons born or naturalized in the United States, subject to the jurisdiction thereof, are citizens of the United States, which they're fighting, of the state wherein they reside. So, and then we've got privileges and immunities here. And then down here it says, and it's hard to read again, but here we go. United States, nor shall any state deprive any citizen of life, liberty, or property. No happiness there. Oh my God, I got the puzzle. All right, fingers crossed, everybody. Let me just get the puzzle here. Did I do it? Oh, I did it. Oh my gosh, it's so stressful. All right, back at it. So life, liberty, or property, that's a key piece here. Is your life being threatened, your liberty, so you can't leave, or your property without due process of law, right? We've talked about due process. Nor deny any person within its jurisdiction the equal protection of the laws. That's the piece where they're like, they don't get equal protection. It's like, well, it's right there in the Constitution. It's right there in the Constitution. So there you go. Oh, we hit it. Okay, big grandma. I'm glad you let me know. All right, I've got just a couple paragraphs left here, everybody, and then we'll do our bonus case. All right. So I've just got so many things to tell you all. I'm just like, ooh, look at this and look at that. All right, let me rush through here and then we'll do our bonus case. Exceptions. The standard exceptions to the Fourth Amendment warrant requirement apply equally in the context of Form 1-205. So all of our warrant exceptions will also go to this administrative warrant. Again, that would be search incident to an arrest, impoundment is another one, probable cause. Sometimes you can just see it, and that's in the Carroll Doctrine. Plain view, plain smell, that's another one. So there are just a ton, and consent, of course. Those are the exceptions to our criminal warrants, and they're saying there are also exceptions here. Now, cube officers and agents may obtain consent. Do that. Why don't you go ahead and do that? To enter a residence, including the residence of a third party to make an arrest. Consent for entry must be provided voluntarily, which has been defined by the courts, by someone with authority over the residence. And that can't be your neighbor who's house sitting for you, and may be limited in scope to certain areas of the property. So you can say, sure, come on in, but I'm only going to let you look in the kitchen. They don't like that, but you can do that. Consent for entry may be revoked at any time by the authorizing party. And I'm glad they added this in to remind everybody. If you say, sure, come on in, and then you're like, ooh, I forgot about those black market chihuahuas, I forgot about them in the back room. You can say, nope, I changed my mind, get out. And that's fine. That falls underneath what you're allowed to do with consent. I don't recommend it. I recommend at the very beginning saying, I'm not going to consent to you coming in my house. Then I don't have to worry about the chihuahuas. You know what I'm saying? Next, in the absence of a judicial warrant or Form 1-205 combined with an appropriate final order of removal, exigent circumstances, right? So that's an emergency situation, can allow for the cube officers and agents to make entry into a residence. Now, exigent circumstance doesn't mean like, I got to call my mom back. No, I mean, you need to be like, it has to be pretty bad. Like, look, my house is on fire. Let's not search it at the moment. Some examples of exigent circumstances include 1, hot pursuit. That's one of my favorite ones, everybody. I know, I've got the bonus case, but I just have so much fun in here. Hot pursuit. Oh my gosh, it's so fun. That's my favorite. Anyone watch the Dukes of Hazzard back in the old days when it was okay to have a racist show? I'm just curious. Right? Dukes of Hazzard, they always would go running from the sheriff and they would chase after them, but they would cross the county line. And so they'd have to like stop right there at the county line, right? Because it wasn't their jurisdiction anymore. Who's with me? Am I just talking to myself about the Dukes of Hazzard? Oh, thank goodness. Thank you, everyone. Yes, Boss Hog. That's right. You got it. Okay. Now that's what I like to use to show hot pursuit, because then at the line you would have the other sheriff like catching the Duke boys, right? So the thing is, if you're in hot pursuit of something, you can keep going. So they stopped at the line because it made for a good show, but technically hot pursuit means you're going into another jurisdiction because you're chasing after somebody. All right. So a more frequently used hot pursuit situation could be city police versus university police, right? So if you're in a place with university, they've got their own little cops there. I don't know if they're little or not, but they've got their own cops there. And then you've got the city cops, right? So someone goes and grabs a subway and they're like, I'm not paying for it. So then the campus people go, and then all of a sudden they've crossed the railroad and they're into the city. So now the city folk need to come in and start pursuing the sandwich person. All right. So hot pursuit is allowable in certain situations. I could go for days on that, but he was a decent character. And I actually liked, was it Chickasaw? I can't remember. I really liked the sheriff from the other county. He'd just be standing there and he's like, not my county. It was so funny. I digress. Sorry, everybody. Hot pursuit is the thing. 2, probability of destruction of evidence. Right. 3, possibility of violence. 4, knowledge that a suspect is fleeing or attempting to flee. And 5, a substantial risk of harm to the persons involved or to the law enforcement process if the officer or agent must wait for a warrant, which is the grounds I always went on. When I would get called, again, this was a while back when I was a prosecutor, before it was a while back. What I would say is secure the scene, go get another warrant. Sometimes they even have a warrant. It's like your warrant's not going to cover everything. Go get another warrant. So they run back to the magistrate, get a second warrant, and then come back because the scene's been secured, and then can use that second warrant. That just cleans up a messy search if you do it in the right way. Again, not legal advice, everyone here. Yes, get some tang, right? Oh my gosh. Oh, Daisy, she's amazing. Very talented. Still is very talented, quite frankly. Right, the bots are weird today. All right, well, let's wrap this up here. So the above information should serve as general guidance for consideration prior to and when effectuating an arrest in an alien's place of resident using Form 1-205 in combination with final order. Again, this is really important and not something that's hitting the news, that there has to be a final order involved by an immigration judge here or these various people. Please direct any further questions to your management and the office of the principal legal advisor. I don't know if anyone's still there or not. So that's the other question here. All right, so that was the, oh my gosh, that was the memo, everyone. Now, let's get into the bonus case. Goodness gracious, I was just talking too much. That's all right. We'll come back to it. We're going to make some time up here in the air. All right. Our bonus case for tonight. Oh my gosh, this is such a fun. Well, I mean, for me, it's fun. I have actually done a full post on this case, so you can search my name and the name of the case, and it should come up. All right, let's make sure. Okay, here we go. Make sure I got the right bits and bobs here. Okay, here we go. So the first thing I'll say is, of course, this is a landmark constitutional law case, freedom of speech, all right? Gosby Lopez. We love that for us. The thing here that you need to remember is this was in 1975. So they were setting landmark law at the time. This was the Burger Court, right before, I think. I know, I can't help it. Hello, Toodle. Take off the tapper. Oh my goodness, everybody. Thank you so much for the taps. Thank you. It's a team effort. I appreciate you all. Oh my gosh. All right, here we go. Let's dive into this one. This case just cracks me up. So 1975, picture it, right? Picture what's going on in 1975. Facts of the case. So 9 students at 2 high schools. I think this was Alaska. No, it was Ohio. 9 students at 2 high schools and 1 junior high school in Columbus, Ohio, were given 10-day suspensions from school. The school principals did not hold hearings for the affected students before ordering the suspensions, and Ohio law did not require them to do so. So we're dealing with public school here. The principal's actions were challenged, and a federal court found that the students' rights had been violated. The case was then appealed to the Supreme Court. Now, before we get into the Supreme Court, let me just give you, let me see if I can just give you a little bit more information here. Academic freedom, no. Let me see here. All right. Well, I'll just tell you the story. I'll just tell you the story here. All right. They tried to make it, by the way, a class action. So my understanding here is that this was the group, and I might be wrong, VC. Feel free to double check me on this one. But I think I think this case was the one where they had the Olympic torch. Is that right? The Olympic torch was coming through. And so the high school kids decided to make a sign. And it wasn't good. And the students walked out. True. My sisters would fly away. Oh my gosh. All right. Let me flip over onto on the other page, everyone. I'm starting to be like, wait a minute. This one is the right case, isn't it? All right. Did the imposition of the suspensions without preliminary hearings violate the students' due process rights guaranteed by the 14th Amendment? Do kids in school have a right to due process under the 14th Amendment, right? So then it was a 5-4 decision here. Yes, in a 5-4 decision, the court held that because Ohio had chosen to extend the right to an education to its citizens, it could not withdraw that right on grounds of misconduct, absent fundamentally fair procedures to determine whether the misconduct had occurred. The court held that Ohio was constrained to recognize students' entitlements to education as property interests protected by the Due Process Clause that could not be taken away without minimum procedures required by the clause. The court found the students facing suspension should, at a minimum, be given notice and afforded some kind of hearing. So the whole issue on this was the whether or not that negative of a penalty for these students could be done without giving any kind of notice or opportunity to be heard, because that, I think, is kind of close also to our administrative or quasi-criminal question. Hold on, I just got to make sure which, because the thing is, I've got two cases in my head that involve PENIS, and I can't remember if this one was the big sign or the little sign. So I have to look it up. We're on 18 or older, everybody. One moment, please. For some reason, I have forgotten which one. I don't want to say the wrong one. Oh my goodness gracious. All right, just a minute. Oh my gosh. You use this against me later, that's fine. All right, public schools. So they were outside, right? Okay, school principal, law requires blah, 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 blah. If they were suspended. Okay, just 1 second here. Ooh. Sorry. Right. Hold on 1 second. Again, it's like how many times do we have cases with that particular item involved? And apparently it's 2. Protecting the meaning of the word, right? Suspended 10 days. Okay. This one was the second one. Argue this violated their 14th here. Yeah, this I think is the second one. So we have property damage and sit-ins. I think we had, which should be enough. And we've got this question of when they're outside of the school. Is that okay too, right? Public high school, here we go. 10-day suspension. I'm looking here for the facts really quick. Board can reinstate, declaration, proof below. Where is the PENIS, man? Was it on a poster board or was it on a piece of fabric? Oh my gosh. Sorry, everybody. Just 1 minute here. All right. It looks like just a general, oh my gosh. Seriously? Okay. I was thinking of Roth. All right. It's not Roth. So this is the picture one. Anyway, everybody, the point was, that these students, these 9 students, were out and about and not sitting in the seat at school. And so there was this question of, is it going to cover all of the students? And they say, yes, it will. We got to have at least something. Right, where's the beef? Oh my gosh, yes. It's an academic freedom case. Oh my gosh, I'm sorry about that. I was so careful. I was like, I can't print anything out. We don't want this to turn into the Hunter situation. No, we do not. Oh my goodness. All right. So academic freedom lies not in the comfort or inconvenience of teachers and students, but in the benefits to society. The long-term interests of society are best served when the educational process leads to the advancement of knowledge. And knowledge is best advanced when inquiry is free from restraints by the state. All right. Well, there you go, everybody. I could have done this one better. But, I truly forgot that we had two cases involving that. Don't tell anybody, all right? Yes, for the sticky notes and such. But anyway, with that, this is going to drive me crazy all night. I mean, you can't just walk around carrying a sign like that on school property, even if you're outside. Right. Let me see here. Right, so due process before suspension, everybody. And also, I do not recommend certain things being put on poster board when you're protesting at a school. All right, I'm against that. Can't find the original problem. Yes, that's right, sissy, but it's only one of two. The other case, the other case, I think, was a speech given by a student that was very suggestive, and that was a First Amendment issue. And the student was like, "Whoa, what are you talking about?" And then we had another one that was bong hits for Jesus, and that's the fabric one. That was a huge sign that they had. A whole bunch of kids were holding it up, and they were across the way from the school, and the school was like, "You need to get rid of that," because like the Olympian fire bearer was supposed to be coming through town or whatever, running through with the torch for the Olympics. And they had this huge banner that said "Bong hits for Jesus." And the principal was like, "Get that out of here." They're like, "No, First Amendment." Oh my goodness gracious. I know, right? Oh, I know. Well, I'll have to do that one next time. So, but these are, again, in a group of what kind of rights do you have in high school? What kind of rights, do you not have? Because many times what can happen is they're like, here's your suspension. We don't care about anything you want to say. But education's at a level where you need to have a hearing. You need to have something in place to give the kids a chance to say, what's going on and for them to understand why they're being punished, right? So kids will be kids. Still trying to find the problem. It's actually, you should pull the speech of that one. No, don't do that. I'll defend my son for that. Heck yeah. I mean, I'll give my son poster board for that. Don't say that. All right, everybody. All right. So that was my case here for tonight. Bonus is a little bit different here. I'm gonna have to write myself a note. Get second PENIS lawsuit. All right, I'll do that as our next bonus. Oh my gosh. With a ruler. I know. I'm just so innocent. It's just difficult. All right, everybody. We went around the bend on that one. Oh my goodness. All right, so we were able to at least get through this memo. I do want to go through the whistleblower, so I will probably do this tomorrow. I am going to be trying really hard to make sure that I'm popping up as much as possible here. I know, that's probably shouldn't have spelled it, but y'all know what I mean. Anyway, we'll go through this in the Fourth Amendment a little bit more when I come back. Thank you all for coming and hanging out with me. I truly, truly appreciate it. Take care, everybody, and I'll be back again soon.